Hey everybody, JTO here, John the Other, obviously. And today I'm talking about an article that I have just seen on a website called CanadianLawyerMag.com, where it is talking about a decision made in the BC Court of Appeal, quite an important decision for male reproductive self-determination, which is a set of legal rights that men don't have, and when you say reproductive self-determination, that's a set of legal rights that women do have. The decision is basically, it's called, the decision is Lamb versus University of British Columbia, and the article reads, is the latest legal chapter in a long-running class action suit against the university alleging negligence and breach of contract over a malfunction of a freezer in its andrology laboratory. What apparently happened is that a number of male cancer patients had semen that was stored in a frozen storage location. There was a power interruption and it thawed out and spoiled or something like that. And it is believed that these guys are entitled to some compensation because the decision is that their semen is their property. It is private property. This isn't just an issue of private property, though. This, I think, has quite far-reaching implications in, taking tiny baby steps towards men having the legally recognized right of reproductive self-determination, which right now they don't have. Of course, as soon as this conversation comes up, as soon as this topic is raised, there is the standard howling counter-argument that, a woman's body, a woman's choice, and men don't get pregnant, and you should have kept it in your pants, dude. And you're a deadbeat, and so on. You're an irresponsible father. Well, women have the legal right to control their fertility. They have the legal right to get pregnant and to not get pregnant. And they have the legal right to continue a pregnancy or not continue a pregnancy. They also have the legal right to give a child away for adoption afterwards or not do that. And the father has the legal right to shut the fuck up and do whatever it is that she decides. Now, in almost all cases of people having babies, it's made by some sort of a consensus. It's two people who agree that they want to have a kid or not have a kid. But in situations where there's a disagreement, where she wants to have a baby and he doesn't, well, he can just suck it because he doesn't have a legal voice. He might be able to persuade her, but there's no binding in law of his opinion. And in the opposite case, where she does not want to have a child and he does, he can, again, suck it, because he does not have a legal voice in that decision. It is her legal voice. Now, there's obviously limitations on when you can terminate a pregnancy. If it's, I guess in the late term, a lot of people view that as killing an infant, killing a child. Well, maybe there's some element of truth in that. But the fact that semen, sperm, has been determined in law in a BC Court of Appeals to be property has really far-reaching logical, and I think probably legal implications as well. Namely, and before we continue that train, I'm going to sort of go off into left field here and talk about agricultural law. There is a company that most people will have heard of called Monsanto. Monsanto is, agricultural and food-producing multinational mega corporation, and one of their practices that's fairly well known is they genetically engineer seeds for, corn and barley and wheat and whatnot, sell those seeds or license those seeds to farmers for a fee. But if the seeds blow into an adjacent farmer's field by the wind, and that farmer whose field they let those seeds might land in does not have a license for that seed from Monsanto that he's paid for, and the seed germinates and grows and gets found, those farmers can be sued into extinction. And there's a history of Monsanto doing that, and sometimes seizing the land because of an accidental seed blowing into their land and the farmer growing it without even realizing it. Well, if you don't see a parallel here, we'll point it out to you laboriously. If a woman becomes pregnant, if a woman chooses to become pregnant, or gets pregnant and chooses to remain pregnant, against the wishes of the man whose semen was used for her to get pregnant, there is now an established recognition in law that his semen is his private property. So we are one very tiny step towards, I think, male self-determination in reproduction. That you can't use my semen to have a baby. Now, you probably obviously can, because you're not going to, like, kill... Oh, it's discovered, little Timmy, that you were born from an unlicensed pregnancy, so we're going to take you out back and shoot you. It's not going to happen. But what is much more likely, what is much more reasonable, is that the courts being used to excise money, to appropriate income from somebody who is an unwilling father, whose semen is used without their permission, without their willingness. Sometimes women, there's a number of cases where it's been talked about in the media where women have stolen semen from a used condom and got pregnant that way. I think that's pretty rare, but it happens. And where a man does not agree to become a father, where he does not agree to have his semen used in reproduction, I think there is now at least the beginning of a legal precedent that he cannot be forced to pay for a decision that he has no legal rights over making. And I'll link to the article in the low bar, and I really hope that this is explored in law, and that this precedent is exported all over the world. Thanks very much for watching, and have a lovely day.